Next, here is a brief introduction to the Landlord and Tenant Act 1954. Subject to certain exceptions, this Act gives tenants holding business leases statutory rights of renewal at the end of the contractual term of their lease. You may hear these rights referred to by reference to the term security of tenure. Leases that are subject to the protection of the Act are often called protected leases. Sometimes tenants' rights of security of tenure may be defeated by a landlord. For example, if the tenant is in arrears of rent or in breach of some other terms of the lease, or if the landlord has an intention to redevelop the property or occupy it itself for its own uses. If a tenant with security of tenure is unable to renew its lease because the landlord successfully defeats a claim on a ground where the tenant is not itself at fault, the tenant may be entitled to statutory compensation. Moving on to a basic outline of how the 1954 Act exclusion process works. The Act was made in recognition of the fact that business tenants can stand to lose goodwill that they have built up by trading from specific premises if they have to leave them and move on somewhere else when the contractual term of their lease expires. Tenants do, however, very frequently agree to give up these rights. This agreement will be recorded in the lease and will need to be properly authorised. For virtually all leases that are granted today, authorisation is by way of the tenant making a specific declaration confirming that it knows that it is giving up its rights in response to a formal notice that is served by the landlord. Leases that are granted following this process are often called contracted out, non-protected or excluded leases. The question of whether or not the tenant will give up its rights is one that is usually addressed at an early stage of negotiations for the grant of a lease. A landlord may simply not be prepared to grant a protected lease, or may want to charge an increased rent for it, or may be prevented from granting a protected lease if, for example, the landlord's own interest in the property is leasehold. The terms of the landlord's lease might prohibit it from granting underleases that are protected by the Act.